What is up, guys? Welcome back to Truth and Transparency. It's been a hell of a past 48 hours over here at Truth and Transparency. Woo! But it's been a hell of a past, 4 years for Karen Read, and she deserves, as much as I want to see this go to a trial number 2, Karen deserves to have this completely thrown out with, prejudice so that it can never be used against her in any form capacity. Karen Read and her team file a straight fire motion to dismiss for extraordinary governmental misconduct. Karen Read is asking that Lally, Louster, for the reasons above, Ms. Read respectfully requests that this honorable court grant defendant's motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under the circumstances, in the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues, attendant to the Brady violations and juror interference. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant Buchanan, Colleen with 1L, Crawford, and other members of the CPD. Oh, and by the way, Lieutenant Fanning. Yeah. So, woo. If I was John McCabe and all those other fools, I'd want this to get dismissed because I wouldn't want to have to take the stand again, especially Matt McCabe, especially Tully. All these guys. Okay. Why wouldn't you be rooting for it to get dismissed? Because you don't want to be. I'm not taking the stand again, right? So with that said, I thought about it from that angle as well. And it's just kind of like, why isn't this happening? So let's see. Again, this was filed when was it filed? Yesterday? Today? So here we go. Again, this is just for the motion to dismiss and why these people would be needed. This is just that motion to dismiss. Those people would be listed. And that was just specifically to the Brady. So now comes the defendant, Karen Read, Miss Karen Read. You sound so excited about that, Lana. I do. I'm so excited about all of this stuff. I really could imagine. I've gone through some crappy ass situations, but what Karen Read's going through is just it's unprecedented, and it needs. I want to see full accountability from these pricks. We, the people, need to put this in check. So here we go. Now comes Karen Read, and respectfully moves this honorable court pursuant to Article 12 of the Massachusetts Declaration of Rights, the 5th, 6th, and 14th Amendment. A prosecutor, quote unquote, may strike hard blows. Shake it for that one. A prosecutor may strike hard blows, but he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as is to use every illegitimate means to bring out a just one. Boom. That's just a great boom. Throughout the course of these proceedings, I don't want my other work to overshine here. So throughout the course of these proceedings, Ms. Read has been severely prejudiced by the Commonwealth's pervasive misconduct. The Commonwealth has suppressed discoverable and exculpatory video surveillance footage from the Canton Police Department. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started. As we all are aware, those of us that are following it. People don't be mad about the redactions. The redactions are to protect Karen because she does not want these people to have a heads up on what transcripts, what was written in the transcripts. So again, they're getting all this video surveillance being piecemealed to them and started after the trial. After the Commonwealth represented that, quote unquote, all video footage had been provided to the defense. For reasons that remain unexplained, much of the video that has been disclosed is, quote unquote, missing critical timeframes and evidence central to Ms. Reed's defense. Some of the video clearly appears altered or manipulated, as evidenced by people, quote unquote, appearing and, quote unquote, disappearing out of nowhere. At the first trial in this matter, Assistant District Attorney, ADA, that's what ADA stands for, Assistant District Attorney, Adam Lally, brazenly introduced inverted video and elicited patently false testimony from MSP Sergeant Yuri Bukaki that the video was a fair and accurate depiction of critical events in an attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the right rear taillight of Miss Reed's SUV. There can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was, in fact, standing directly next to the right rear taillight. Other Sally Port video, which was unquestionably favorable to the defense because it would have severely discredited key witness Brian Higgins, known as Higgy Boy, inexplicitly was not disclosed to the defense until months after the first trial. This is what's amazing, guys, is to this date, when this document was filed, as in like yesterday, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Sally Port video and why some video was suppressed from the defense at the first trial has made a mockery of Miss Reed's right to due process, which is our motherfucking right. You wrong one man, you wrong us all. What's up there, December? Holly in chat, y'all. Murky, give it up for Carson, all the mods in chat. If I missed your blue wrench, rock on. The Commonwealth exploited this court, the court's order, instructing the defense to disclose its impeachment material in advance of witnesses testifying. That means we can give it to you and everything like that, but you are not allowed to then turn around and go use it to beef up and protect your key witnesses. I like to call them piggins. So again, the Commonwealth exploited this court's order instructing the defense to disclose its impeachment material in advance of witnesses testifying. ADA Lally and MSP Lieutenant Brian Tully huddled, what a great word, huddled with key witness Jennifer McCabe mid-trial, prepped her on how to explain why she never disclosed that she went to CPD Sergeant Mike Lank's home one day, exactly one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. Gary Roberts. If the Commonwealth had complied with their obligation to provide statements of witnesses before they testified, the defense would have positioned to expose McCabe's material inconsistent statements about her meeting with Sergeant Lank. This is redacted, but trust me, guys, it's nothing that we don't already know about. Okay, it's so that they don't see the police report, meaning Jennifer McCabe doesn't see a police report, doesn't see what it says. Okay. As a result of this extraordinary governmental misconduct, Miss Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm against or caused to Miss Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession. You have a right to face your accusers. You have a right to obviously have this material that, known as Brady. And how do you put the genie back in the bottle, per se? Like, I mean, this is total grounds for a dismissal. And I'm struggling to understand why they won't do it, other than the fact that they think that Miss Reed's going to sue them civilly and be awarded a shit ton of money, because why would any of these people want to take the stand? Like, don't put us in this situation. Okay. Accordingly, the case against Miss Reed must be dismissed with prejudice, meaning without prejudice means you can come back and charge her again. With prejudice means you can never charge her again for this crime. Now, the statements of facts. Let me talk about coming out like boom. Miss Reed is accused of the following crimes. We know those crimes. A month-long jury trial was held in this matter beginning on April 17th, June 25th. The jury began deliberations. After the jury submitted a note to the court indicating that the jury was at an impasse, the court declared a mistrial on July 1st. The Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury in a case in which the jury either voted to acquit or was deadlocked on the lessers of one charge. There is no cure short of a dismissal with prejudice that can remedy the serious constitutional and statutory violations. That have occurred in this case. Now, the one thing that we will get out of this, guys, is we will get March 5th, you guys, it's going to be a party up in here. Because we may not get a trial 2.0, but we will have this evidentiary hearing. We just got started here. And that may be trial 2.0. Because I don't think that this should go any further. But watching all these people take the stand who they want to call, hence why I believe Mark Betterow was put on the ticket, and hopefully he gets on the ticket. So the facts relating to the respective misconduct and discovery violations are set forth below. So here we go. A, facts relating to the destruction and withholding of exculpatory CPD video surveillance footage. This court is aware of the critical importance of the video surveillance footage from the CPD on January 29, 2022. The Commonwealth has produced dribs and drabs of various clips of video surveillance contained from the CPD's ExactQ Vision DVR system from January 29, 2022, without any accompanying reports. This is unheard of. Evidence logs or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. I was reviewing over Tully's testimony from last trial, and I paused it at a very interesting part. Number 1, related discovery orders. On February 2nd of 2022, so back over 3 years ago, the defense filed defendant's emergency motion for preservation of evidence, including the preservation of all physical evidence, such as video surveillance footage. This would be, John O'Keefe is, the 29th, February 2nd, 2022. We are in 2025. But this was made that soon. The preservation of evidence, including the preservation of all physical evidence, such as video surveillance footage, with the Stoughton District Court, Exhibit A. February 2nd, 2022, order on motion to preserve evidence. At February 2nd, 2022 hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the district court issued a preservation order for all physical evidence, which includes video surveillance footage. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmation obligation to preserve any and all video surveillance footage in its possession, custody, or control, which would definitely include the Canton Police Department and or Massachusetts State Police. And ADA Lally was required to notify law enforcement of this order. On September 16th, 2022, so then you're going to go through February, March, April, May, June, July, August. Now we get to September 16th, 2022. After Ms. Reed's case was transferred to the Norfolk Superior Court following her June 9th, 2022 indictment, the defense filed a separate motion to compel the production of certain outstanding discovery, in quotes, including all crime scene photographs and or videos taken in connection with this case. See Exhibit B. So those exhibits were attached to this motion to dismiss. On October 5th, 2022, this court granted the motion to compel in part and ordered that the Commonwealth produce all video evidence and metadata associated with the video of the date. Metadata, what a great word. Number 2, dates of production and facts relating to discovery and constitutional violations. The CPD's video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29, 2022. This is redacted so that they can papow people so that they don't see that. Notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years. Remember, Karen Reed just did an interview, and she kept on talking about how she's always behind the 8 ball because they were never given stuff. Meanwhile, they had all this time to get all of this shit in order and yada, 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 yada. So they had all of this in defense for more than 2 years, failing to disclose even the first incomplete batch of the footage until the eve of the first trial on April 4th, 2024. You guys, this is unreal. Unbelievable. And that's why Alan Jackson asks Tully about, there's the grainy video and then there's the Sally Port non-grainy video. Whew. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the CPD on January 29, 2022. April 4, 2024 production. On April 4th, on the eve of the first trial in this matter, the Commonwealth, for the first time, disclosed woefully incomplete CPD video footage, which consisted of video from the quote-unquote the CPD main driveway, the Canton Police Department Sallyport front wall camera, and then you can see the notice of discovery XXXV. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Sallyport garage. And then providing these exhibits, Exhibit D for good old Bev to take a look at, and then Exhibit E. The missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the CPD's Sallyport garage. B, the individuals who had access to the right rear taillight, and C, whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the right rear taillight of this Lexus SUV at the time it entered law enforcement's custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2nd, 2022 preservation order, which means that the defense has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. You know you a badass when you are redacting footnotes, ladies and gentlemen. Cheers, Karen Reed, trial watchers. Criminality, what's up, girl? Like I said, you know you a baddie when you redacting your own footnotes. B, April 10th, 2024, the Commonwealth files its certificate of compliance. Like when you file that, it's like, hey, we met our obligation. We did what we were supposed to do. You guys footnotes never get redacted. That's how awesome that footnote is. Okay. On April 10th, the Commonwealth filed the certificate of compliance in which ADA Lally, he certified this to the court 6 days before trial, that the Commonwealth, after exercising reasonable inquiry and due diligence, in quotes, to the best of their ability, disclosed and made available all items subject to discovery. Exhibit F, which then showing his certificate. That's a big thing in the worlds of like lawyer-esque, when you're certifying, when you're when you're doing your verified, it's just like an affidavit. It's a big old deal. So April 10th, that all happens. Emphasis added. I love it. This representation was patently false. It strains credibility, where was I? That ADA Lally, in light of his actual knowledge about the preservation order and existence of extensive Sally Port video would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody, and control. At a minimum, rather than mislead the court and the defense, ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance footage. Footnote 3. See Mass Rule of Professional Codes of Conduct 3.4d. Party may not fail to make reasonably diligent efforts to comply with a legal or legally proper discovery request. Like once he would have, like he knew they knew it. Okay. April 23rd, 2024, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Miss Reed's SUV. Redacted right here. And then footnote 3, ADA Lally was cognizant of other discoverable material that the Commonwealth did not disclose before certifying his compliance with his discovery obligations. Notably, when filing the certificate of compliance, he expressly represented that the quote-unquote lone exception of outstanding discoverable material was some evidence related to DNA testing and analysis. See Exhibit F. Again, redacted to right here. On April 23rd, 2024, the Commonwealth produced additional footage from CPD, Sally Port Backwall, via a share link entitled Additional Sally Port Video Download Link. And see how this says share link? I'm going to do a different video down the road here to talk about the fact that if something is in a share link like that versus in a thumb drive, a thumb drive had to come from somewhere. Okay. And we'll get into that when I do a video down the road. Okay. The Commonwealth. I'm sorry. See, no flash drive was presented to the defense. See, I got in front of myself because I knew that, which is really, really important. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the right rear taillight of Miss Reed's vehicle after it entered the Sally Port. Like, we don't care that Proctor is a disgusting pig. He can say all that stuff, guys. It did not affect his job. The rest of CPD's job, the rest of MP, everybody's job. That's why that video was so damn important to present. Okay. It was that was a last ditch effort to, hey, we still have credibility here. Take a look. Okay. And that's why I think it's even that's even worse in my opinion. Right after, Bukaki, he went first. And so right before the big explosion was to happen about the guy that's going to say cunt, whore, whatever, we're going to do the inverted video. Okay. So that's what I think is just even the most egregious part of it, is that the Commonwealth knew that Proctor was about to get destroyed. And before that happened, they put this in. The inverted video. Okay. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached it. ADA Lally craftily, look at these adjectives. Dude, this is such a Lana motion. Bella said it best. She's like, dude, whoever drafted this pulled a couple Lana-isms in here because you're not supposed to write like this. Well, because this is being a little, that's your opinion. You know what I mean? But I was like, oh my God, I love it. This is such Atlanta writing. ADA Lally craftily elicited testimony from Sergeant Buchanan that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29, 2022. And that in quotes saying, as seen in the video, end quote, no law enforcement officer approached the right rear tail light. Please see Exhibit I. These are straight out of the, this is straight out of the transcripts. Lally. Okay. Love it. Love it. Like, that's why you remember when I kept on getting so mad? I'm like, why aren't they objecting to leading? What the hell is going on here? Stop letting Lally lead these people. Well, here's a really good example of, hang on, let him lead him, because they knew that they had Lally on misconduct. Okay. And here, this is the big pow. So ADA Lally, you did this, buddy. You said, as seen in the video, no law enforcement officer approached the right rear taillight. Now, on cross-examination, however, Sergeant Buchanan, his testimony was exposed as profoundly misleading at best and perjurious at worst. You can decide right there, Bev. It became apparent, though, that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. And this is the part of the Tully, when Alan Jackson has Tully on cross, and he's like, okay, I want to talk about the Sallyport. First, I want to talk about these videos. When you received the video, did you look at it? Did you look at it? So you viewed it, right? Is that right? So Alan Jackson asked very crucial questions to rope these mofos in on this shit. Okay? So it's going to be freaking poetry when we have this evidentiary hearing for this motion to dismiss. That's why she set aside all those days next week. Pow, 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 pow. Woo! Sorry, I'm just getting so excited over here. Next week is going to be like March 17th came a couple weeks early. It's like March Madness is beginning, guys. And it literally is beginning because March is about to be off the chains in the Karen Reed case. So yes, on cross-examination, Alan Jackson exposed it. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. Critical facts which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court defense or the jury. In other words, this video made the left side of Miss Reed's SUV appear to be the right side. The Commonwealth never filed a supplemental certificate of compliance. I love it. Slide that in there too. So true. And the right side, we made that seem to appear like it was the left side. So therefore, the video presented to the jury as quote unquote fair and accurate appeared to show a person who, Trooper Proctor, standing near the left side rear taillight of the vehicle when in fact Trooper Proctor was standing near the right rear taillight, i.e. the taillight at issue. Moreover, the inverted video does not capture the condition of the right rear taillight, and it conceals Trooper Proctor's presence by the right rear taillight. This leads to the inescapable conclusion that ADA Lally's questions, Sergeant Buchanan's responses, and the deliberate introduction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and Miss Reed with respect to a critical issue in the case. On October 10th, 2024, the Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. So now, fast forward to just before the holidays, Post-trial, on October 10th, 2024, the Commonwealth again provided new footage. This is the big, here it comes. This is where we see Higgins provides new footage, this time from the CPD church side exterior. Well, we've never heard that before. Church side exterior. First floor corridor, rear lot main side, and rear lot cruiser side. Hot damn! Is that 4 new views? Hot damn! Let's just highlight those little special. Those look to be special for us. Okay, good. There it is. Woohoo! Oh, that's in our new. That's notice of discovery is nod right there. See that? There it is. Wow, that's a special, man. I can't believe that you can do this stuff. Why didn't we all become lawyers? Okay. Now, this footage shows Piggins. Welcome to the game. Piggins. And this goes hand in hand with what I'm in the process of revealing. When he was on the phone at 1:34 a.m., you know, it's going to be really, really important to know who he was talking to, right? Because that's going to be huge, right? Huge, huge, huge. Now, we know that it wasn't Jen McCabe's phone, right? But I have a feeling, what if it's Matt McCabe's phone? Would you guys just not shit up Rick? We'll carry on, though. So Higgins arrives in the parking lot of the CPD at 1:26 a.m. Totally crushing. Okay, we had like the swipes and stuff like that. But here, 1:26 a.m., he enters the building and speak to some unidentified individual or individuals on the phone as he is leaving. Now, I think it's interesting and telling that they say individuals like this. And if you think back how Yannetti and Alan Jackson always questioned like Matt McCabe, oh, well, correct me if I'm wrong, but we'll just say like you guys, because if it was on speakerphone, it's multiple people, right? Is that right? So I think that's really interesting that they put plural on who could have been listening in on that phone call. And it's because of the way that Matt McCabe and Jen and people were testifying to being able to hear things because it was on Bluetooth and speaker and blah, 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 blah. So, but Higgins is on the phone and he is seen entering and then leaving on the phone at 1:34 a.m. And that's Exhibit K, Higgins, rear lot. Now, significantly, this specifically requested material and relevant evidence, which establishes that Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton Police Department shortly after O'Keefe's death, was suppressed until after the first trial. And then here's this redacted. And then we move. It's just going to be his, what he testified to. It's going to be his quotes, and they don't want to give those up because we don't want him to know that. So E, the Commonwealth failed to preserve exculpatory video surveillance from January 29, 2022 in violation of a court order and Brady. Now we get to Brady. Whoo-wee. On November 8th, 2024, while preparing for Miss Reed's second trial, so this is just recently, and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, Attorney Elizabeth Little emailed Special District Attorney Hank Brennan, again requesting all raw video footage from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and or the exterior of the CPD, including all parking areas, entrances and exits, and garages between January 29, 2022 at 12 a.m. and January 29th at 11:59. On November 25th, 2024, a couple weeks later, ADA Brennan indicated via email that he would request that CPD provide all requested footage. Ultimately, the defense requested access to the CPD DVR system and drives that hold recordings from the security camera system so that defense expert Matthew Erickson could obtain video files and corresponding log files from January 29, 2022 between 12 and 11 p.m. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the CPD on the morning of December 12, 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Ms. Reed's case via standard forensic protocols, as they were obligated to pursuant to way back February 2nd, 2022, because it should have been preserved and saved on that drive. But now everybody should be asking the question is then where are they getting this footage to be presenting to the defense in October of 2024? During April of the trial, all these years later, where is this footage coming from? So basically you're outing yourself in the fact that you had this shit, right? Because we know that you didn't have it because you saved it properly. You have it because you did something else with it. You saved it somewhere else, or somebody made and has a very interesting copy of it, right? Okay. All right. So remember the order to compel, October 5th, all that. Those are going to be bombshell arguments. Now, January 28th, 2025, just about a month ago, the Commonwealth produces more exculpatory blurry video surveillance. Now, nobody has seen or heard about this yet. This is brand new, even to Truth and Transparency. Okay? That on January 28th, 2025, the Commonwealth produces more exculpatory blurry video surveillance footage establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Sallyport garage. Holy shit. God, I love these assholes. On January 28, 2025, the Commonwealth yet again turned over additional CPD surveillance footage from January 29, 2022. Again, where did it come from? This time from an exterior camera depicting Miss Reed's SUV being brought into the Sallyport garage. And this is, again, see Notice of Discovery, LVI Exhibit M. Main driveway side exterior Sallyport. 1735-000, see that? 535. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Miss Reed's SUV immediately after this vehicle is brought into the Sallyport garage. Guess what, guys? Guess what the swipe of Higgins is? Show me that smile. Don't waste another minute on your crying. 536. Do you guys know what that's from? It's Full House theme song. Everybody's in bed up in here. Full House, baby. 536 is the swipey poo. Booking to Higgins. Higgins to Sallyport. Booking to Sallyport Higgins. Okay. That's right. 5:36 p.m. Swipey poo, higgy poo, all up in that motherfucking Sallyport. Oh shit! This is why I do timelines. Oh, is it Growing Pains? Was that one Growing Pains that I did? I always rip out something new every day. Was that one Growing Pains? Okay. Higgins in some hot, thick water. Now. Okay, let's go back here. So we got this blurry footage, right? The footage, although blurry and grainy, appears to show an individual approach the rear right taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport garage and then exits shortly thereafter. Yeah, Higgins. Is that right? If this video were not blurred out, the surveillance feed would have captured yet another angle of the rear right taillight as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. Facts relating to the Commonwealth's intentional withholding of exculpatory statements made by seminal witnesses named Jennifer McCabe here. Ooh, they're going to go hard at Jenny, girl. Out your fat ass husband, girl. Go ahead and do it. I gave you an out, girl. Do it, do it, do it. I put the full court press on that family. McCabe is a key Commonwealth witness. You guys check out this case law behind this shit. McCabe is a key Commonwealth witness. Her credibility is crucial to the Commonwealth's case. On February 2nd, 2022, mere days after O'Keefe's death, the MSP obtained and forensically imaged McCabe's cell phone. The forensic examination of McCabe's cell phone revealed significant exculpatory evidence supporting Miss Reed's third-party culpability defense, establishing that McCabe Googled "house long to die in cold" at 2:27 a.m. on January 29, 2022, 3 hours before she supposedly, quote-unquote, discovered Mr. O'Keefe's hypothermic body in the snow on her brother-in-law Brian Albert's front lawn. McCabe then took steps to delete that one search out of more than 4,560 on her phone. Matt did it, though. Jen ain't that good. Along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between the Albert and McCabe families and the law enforcement officers assigned to investigate this case is central to Miss Reed's third-party culpability defense. CPD Sergeant Lank, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th, 2022. In preparation for trial, the defense uncovered location information on McCabe's cell phone, which proved that she went to first responding officer Sergeant Lank's home on January 30th, 2022, the day after O'Keefe's death. On May 7th, 2024, in accordance with this court's order that parties disclose all information to be used for impeachment purposes, Attorney Little emailed ADA Lally, "You're going down," and ADA McLaughlin, "Damn you, girl, you're involved in this shit," to provide location information from McCabe's cell phone establishing that she went to Sergeant Lank's house on January 30th, 2022. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tully. Yeah. Get him. Get him. On May 10th, 2024, in a then undocumented meeting, Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Lang was not memorialized in any report or otherwise disclosed to the defense in advance of Ms. McCabe's testimony at trial in violation of Brady Giglio and Rule 14. Sit down. Sit down. No, Matt didn't set up his wife. Matt was using her phone because they never thought in a million thousand years that they would ever ask for her phone, maybe his, because of what they were off doing that night when they got in the car and went driving again, but never hers. So he had done stuff through her phone. Why do you think Jen turned over her phone? Oh, sure, yeah, you can have my phone. Like, because she didn't do it. And she had no idea what the hell Matt did. Okay? Trust. But this is where it even gets better. McCabe testified beginning on May 17, 2024. During cross-examination on May 21st, 2024, she testified that she received a text from her sister, Nicole Albert, on January 29, 2022, stating, "We'll get more information tomorrow." Remember that text? I remember it. More info tomorrow. Don't want to text about it. And everybody looked at that as like that they're in cahoots, okay, in a certain way. Well, I'm looking at this differently now. Okay. The McCabes need the help. Maddie needs the help. Maddie put John O'Keefe on that fucking lawn. Maddie and Higgy poo poo bear. I love it. We'll get more information tomorrow. Don't want to text about it. To which she responded, right. That doesn't seem like a Jen McCabe response, by the way. Right. When Miss McCabe was asked whether anything significant happened the next day, January 30th, 2022, McCabe volunteered the following story. I love how they say story. I went to the O'Keefe's house. On the way home, Carrie Roberts' daughter is good friends with Michael Lank, so we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asked how the O'Keefes were doing. And, we talked to her. She testified that she was at the house for approximately an hour and that she, quote unquote, might have ran in to go to the bathroom, end quote. Because they have that data. On cross at trial was the first time McCabe mentioned going to Lank's home on January 30th, 2022. When pressed further by Alan Jackson, she admitted that she had discussed this issue at a meeting, quote unquote, a couple of weeks prior at the DA's office, end quote. Again, taking it straight from the testimony. She testified that at this meeting at the DA's office, quote unquote, I was told, look at this, I was told, I was asked, were you at Michael Lank's on the 30th? You see that? I was told, I was asked. I love when people get caught like that. That's the best. I was told, like she was told that she was there. I was told, I was asked, you were at Michael Lank's on the 30th? She admitted that at first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation. Thank you so much. Miss Bess, you the best. Oh gosh, yeah. Okay. She further testified that one, Tully did not ask her any follow-up questions about why she went to the personal home of Sergeant Lang the day after O'Keefe's death. And two, that he did not take any notes, like a police report, bro. You know what those are? On May 29, 2024, only after the defense was deprived of the opportunity to effectively cross-examine McCabe. And this is the best part of the whole thing. Thank God somebody decides, you know what? Now is the time that we're going to pound Carrie Roberts, because I have the biggest reveal for Carrie Roberts. You a lie too, girl, and I got your number. Ricky, don't lose that number. There we go. Carrie Roberts, come on down, girl. We going at your ass too. But that's exactly right. We never had an opportunity to ask Carrie Roberts on cross-examination, okay? Because Carrie Roberts went first before Jennifer McCabe. Just like this motion to dismiss says in the beginning, that they strategically did things and released certain things, and it was to, and they're going to say, well, you could have recalled her to the stand. Nope. Yeah, we could have, but we didn't have to. Cross-examination means that I can ask you questions that are leading, and you deprive me of that. And cross-examination is when the truth comes out. Okay? So to say, oh, well, you could have recalled them. No. No. Because, well, then you would have had to give me the opportunity to treat them as a hostile witness so that I could ask leading questions. But that's not going to be the remedy here. Carrie's a talker. Carrie's a talker and stuff. So Lieutenant Tully memorialized his meeting with Miss McCabe, and now in this notice of discovery, again, they just keep doing these notice of discoveries. Exhibit P, May 29th, 2024 report of Tully's interview with McCabe. Notably, Lieutenant Tully memorialized McCabe's inconsistent claim that she went to Sergeant Lang's home to, quote unquote, pick up Carrie Roberts' daughter. I love it. I love these people. I love it. I love the shit show. Lieutenant Tully's May 29, 2024 report, which also omitted any references to McCabe's exculpatory statement in which she denied that she ever went to Sergeant Lang's house, was not disclosed to the defense until June 4th, y'all. Is that right? And then this is just redacted because we're not letting anybody know what that is all about. Look at, I love it. We're not giving any of those hosses. The reason this is redacted is so that Jen McCabe doesn't know what it says. And she's fuming right now. She is so pissed, and I love it. Is that right? Look at that. That section, all that. Oh, how does it make you feel, Jen? Oh, God, that's burning her ass, and I love it. I love it. Oh, my gosh. This is so great, you guys. Nomad Life. What's up? Nomad Life. Loving you're here. Loving all of you guys are here, man. Loving you guys are giving amazing, comments in chat and being part of it. You guys are realizing it and seeing it. And everybody has, for the most part, has seen it and realized it. I mean, this stuff is this is crazy, but this is exactly what happened. And you think that this is a fair trial? I don't care if you think Karen Reed's guilty or innocent. If this is how you would want to go up against the government, okay, then you're a fool. Move. Okay, this is about our rights. As an American, you can have your opinion if you think Karen Reed's innocent or guilty. I don't give a shit what you think about that. I care what you think about this process that happened. And there is no way that you would have any argument to read this, see this, and think and know and say to yourself and your children that you're so proud to live in Norfolk County. And that you would be okay with your kid getting prosecuted this way. And anybody that has that argument and tries to be on that side of it, you need to run from those people because they're a flat out liar. Now, argument. The Commonwealth has engaged in numerous Rule 14 discovery violations and constitutional violations under Brady versus Maryland and its progeny. misreads constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments to the United States Constitution require the Commonwealth disclose certain evidence in advance of trial. See Article 12, blah, blah, blah. Then they have the case law. This is going to be amazing. So you're going to look at Commonwealth versus Mattis, Commonwealth versus Mitchell, and it says defendants have an unquestioned right under the 6th Amendment and Article 12 of the Massachusetts Declaration of Rights to obtain relevant evidence that bears on the question of his guilt or innocence in which otherwise helps his defense. Pursuant to Brady versus Maryland, defense counsel is entitled as a matter of due process to all evidence that is favorable to the accused and material either to guilt or to punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to a test. Citing United States Bagley and Alford versus the U.S., Brady disclosures extends to disclosure of information useful to the defense to attack the reliability of the police investigation and, quote unquote, the police methods employed in assembling the case. Look at this sick case law, Kyle's. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts rules of criminal procedure clearly state that the Commonwealth must provide certain mandatory and automatic discovery of evidence within the quote-unquote possession, custody, or control of the Commonwealth to the defense in order to meet its mandatory discovery obligations under Massachusetts Rule of Criminal Procedure 14A1A. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or scientific tests or experiments, and statements of persons the parties intends to call as witnesses. The Commonwealth is also required to provide any facts of an exculpatory nature. The rules also state that, quote unquote, the defendant may move for discovery of other material and relevant evidence not required by subdivision A1. Here, on February 2nd, 2022, the Commonwealth was ordered to preserve all physical evidence, including video footage, in the Stoughton District Court. Remember, Exhibit A. Subsequently, on October 5th, 2022, the court ordered the Commonwealth to produce all those videos in connection with the case and associated metadata. Again, look at Exhibit B. Notably, this procedural duty to produce evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, which includes the police. The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Thank you so much, Layla Rose Rittenberg from Charlie, Your Sister. Well, that's a nice name. That's a mouthful. Full metal hash values. Absolutely. This is an amazing motion. I couldn't agree more. Full melt hash values. I said full metal. Sorry about that. They've been waiting and waiting and waiting to file this. It's just, this is like the Mona Lisa. All right. This document here. Commonwealth versus Sleeper, Commonwealth versus Tishieri. A prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and presentation of the case. Graham versus the district attorney for Hampton District. Again, C, reporter's notes to Mascom. And then this is just a footnote here down here, which is talking more about the Brady, Maryland case that they totally violated. As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady, Maryland. Number one, so this is now going to show Bev here. This is the Brady, huge Brady violation. So the Commonwealth's production of the April 23rd, 2024 inverted video from the CPD Sallyport Garage violated Rule 14 and this court's October 15, 2022 order compelling the production of video evidence. First, the Commonwealth violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence by withholding the inverted video from the Canton Sallyport until after the start of the trial and after the Commonwealth had already filed its certificate of compliance on April 23rd, 2024. At best, I think that might be a typo. Because I think that they put that on, I thought that was on like the 6th. I think that's a typo. At best, the inverted video had been in the Commonwealth's, so listen to this. This is at best. This is amazing. At best, the inverted video had been in the Commonwealth's constructive possession since January 29, 2022. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear tail light of the defendant's SUV upon its arrival in the CPD Sallyport. And you know what's going to be the stamp of it? The only thing that was inverted, you guys, was the video part. The part that wasn't inverted was the date, timestamp, all of that shit. That wasn't inverted. That's manual. That's manual. That's manual. That is what you call the preponderance of the evidence in a civil case that will win you motherfucking millions. Millions. That is what you call the preponderance of the evidence that would tip the scale in a civil case. Millions. Okay. So remember, at best, the inverted video had been in the Commonwealth's constructive possession. At worst, this video evidence was intentionally manipulated. Fabricating evidence. Manufacturing evidence. This is what Netflix dreams are made of right here. Netflix is just wet over this document. If you guys thought Making a Murderer is going to be a hit, or was a hit, like it was, Netflix is about to rake it in. Just make sure they give me a little cut in there. Talk about Fatty Maddie being the house long to die Googler on the first floor. You know you a baddie. You like that? You know you a baddie when you've redacted your own footnotes. Take that to the bank. I love it. Isn't that great? Thank you so much for the Cash Apps and the PayPals. Sarah, thank you so much. $20 for great detective work. Appreciate it. Let me grab some more water. Actually, I have a shot. Let's see. What do we got in here? Anything? Ooh, yeah. Oh, back. Alrighty. All right. Joined late and catching up. Auntie Bev's fake accomplice. I love it. We're closing it out here if you guys are just joining late. Cheers to you guys. I love it. I love it. I love it. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it had filed its certificate of compliance violated Rule 14. Number 2, the Commonwealth's violation of Rule 14 and Brady by the Commonwealth violated Rule 14 and Brady. Now here again, number 2, by withholding exculpatory impeachment evidence, establishing Higgins was speaking to somebody, and it was an unidentified individual on the phone at the CPD at 1:34 a.m. This is awesome. God, I love it. God, I love it. I would move, man. So after trial in this matter, on October 10th, 2024, the Commonwealth produced previously withheld video surveillance from the CPD's church side exterior and rear lot cameras, which show Higgins arrive in the parking lot of the CPD at 1:26 a.m., enter the CPD, and speak to some unidentified individual on the phone as he is leaving the CPD at 1:34 a.m. The Commonwealth, namely ADA Lally and ADA McLaughlin, suppressed exculpatory impeachment evidence. Hell yes, you go at these. They do not deserve their license, you guys. This is not what you do as a prosecutor, okay? You go at McLaughlin. You go at Lally. They have no business representing we the people, okay? Bye-bye. Go park cars. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory, and that's from Commonwealth v. Harwood. This exculpatory video surveillance footage was in the Commonwealth's custody and control since January 29th, 2022, and at the time of trial was in ADA Lally and ADA McLaughlin's actual possession. By withholding this exculpatory evidence and failing to produce this information until after the trial, ADA Lally and ADA McLaughlin violated Ms. Reed's constitutional rights as set forth in Brady v. Maryland. You are mandated to disclose this. They were also in violation of this court's October 5th, 2022 order compelling the production of video evidence and the ethical duties imposed on prosecutors by Supreme Justice Court Rule 307, Rule Prop C 3.8D. Sit down, bitch. Love it. The Commonwealth violated Rule 14 in Brady by withholding exculpatory video surveillance footage establishing that an unidentified person had unfettered access to Miss Reed's right rear taillight of the SUV immediately after its arrival in the Canton Sallyport garage. And I'm telling you, the swipe of Higgins at 5:36, it's him and it's Berkey, him and Berkowitz, okay? Yes, Pebbles. Pebbles says, I love that McLaughlin is getting her karma. I hate weak women. That's why I want her to sit and spin. You could sit there and do this. I love that McLaughlin is getting her karma, says Pebbles. She was the one who wanted to include evidence to present to the jurors that Karen was searching for an attorney, which is her right. She is just grace. I love it. That's right. Next up. Just last month, on January 28, 2025, the Commonwealth provided additional CPD surveillance footage from January 29, 2022. This time from an exterior camera depicting Miss Reed's SUV as it was driven into the Sallyport garage. Again, Exhibit M. This camera angle should have had a clear and unobstructed view of Miss Reed's taillight as it was driven into the Canton Sallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of a taillight. Notwithstanding that fact, the footage is exculpatory and shows an individual approached the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sally Port and then exit shortly thereafter. This video surveillance footage has been in the Commonwealth's possession since January 29, 2022, and was withheld. I want to know if we can all get a refund and do a class action. Anybody that's donated to Karen Reed, can we do a class action? Because none of this money should have ever been spent in the first place. So, anyways, can we get a class action? Can we get in on this money train? Because it's coming. Karen Reed deserves every penny. This video surveillance footage directly contradicts Sergeant Buchanan's false testimony at trial. And now we going at that fucking block-faced motherfucker. I love it. God, I love it. Get him some love there. False testimony, you sick fuck. God, I love it. I'm sorry, I just love this. In which he claimed that the video surveillance footage established that no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. Miss Reed's defense at trial in this matter was that law enforcement removed taillight material from the Lexus SUV and planted the evidence at 34 Fairview Road. Boom, there it is. The first time ever in print. This is unbelievable to see this in print. Miss Reed's defense at trial in this matter was that law enforcement removed taillight material from the Lexus SUV and planted it at 34 Fairview Road. Oh my God. You guys don't get to see this every day in black and white. I love it. All right. I got about 10 more minutes and we're done. Not even. Notably, no taillight material was found at the crime scene until after the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the CPD Sally Port. Now, I believe that they're going so hard to call out the police like this to see if the police will cough up Higgins and Brian Higgins and Matt McCabe. And I'll get into that another day. So thank you, Sean. $10 for possible Jen and John were messing around. Possible. I put that up there a couple of years ago. Absolutely. Definitely possible. Again, I said notably no taillight material was found at the crime scene until after the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the CPD Sally Port. Any evidence which, quote unquote, tends to impeach the credibility of a key prosecution witness is clearly exculpatory in that Harwood case. As such, ADA Lally and ADA McLaughlin violated Miss Reed's constitutional rights. I love it. Love seeing that. That's dollar bills, y'all. Violating Miss Reed's constitutional rights as set forth in Brady v. Maryland. Mandating disclosure of exculpatory evidence. This court's October 5th, 2022 order compelling the we all know that. And Number 4, the Commonwealth failed to preserve exculpatory evidence in violation of a court order. Allegedly, she's sleeping with Brian Albert, by the way. Jen McCabe needs to get it on. Let's get it on. So the CPD and the Norfolk County District Attorney's Office failed to preserve material and exculpatory video surveillance footage and associated logs in violation of the Stoughton District Court's February 2nd, 2022 preservation order and this court's October 5th, 2022 order compelling the discovery of all videos in the Commonwealth's possession and related metadata. Moreover, the metadata and log files underpinning the CPD surveillance footage from January 29th, 2022 are clearly exculpatory, and thus the Commonwealth had a constitutional and statutory obligation to preserve the original surveillance footage from the CPD in its entirety. To be clear, because we need to be walked through it. To be clear, I also want to thank, I had somebody else send me I did my Irish goodbye on the last time. And so I said to myself, wait, I have to make sure. Okay, yeah. Thank you so much, Sean. Thank you so much, Sarah. And earlier, Wendy said, great work, Mama. Thank you so much. $25. And Barbara said, tail light for tail light wasn't correct yet. Shoe and phone. Gotcha. 20. Thank you so much, Barbara. Thank you. So to be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement's custody is perhaps one of the most critical and highly contested issues in this case. The footage that has been produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability of the CPD's video surveillance footage obtained from the Sally Port on January 29, 2022. The Commonwealth has produced numerous video files without any way to verify their authenticity. And this sounds like me in a courtroom. I'm like, how are you guys authenticating this shit? Where's the chain of custody? Who's coming in to like testify that they turned this over to this person? You know what I mean? Like, these video files include a file capturing the interior of the Sally Port garage with a 42-minute gap missing at the precise time that the feed would have shown an unobstructed view of the right rear taillight of Miss Reed's 6,000-pound SUV as it entered the CPD Sally Port garage. In spite of the fact the Commonwealth claims the video surveillance feed is motion activated, the mid-trial production of an inverted video produced by the CPD in an attempt to save face for the gap in footage, which improperly depicts the right as the left and left as the right, and falsely suggests that no one from law enforcement approached the right rear taillight, and a blurred out video that obstructs what would otherwise be a clear view of the right rear taillight of the SUV as it entered the Sally Port garage on January 29, 2022. It is not a coincidence that none of the many cameras in the CPD Sally Port garage captured the condition of the right rear taillight upon its arrival at the CPD. You guys, think about it. Think about it from the opposite standpoint. How lucky would Karen Reed be, okay, if she truly did hit John O'Keefe and she's able to have all these blunders go her way to not prove that her taillight was in fact fucked up? That's how I tell people to look at it. Well, think about it. Karen Reed should go out and play the lottery. She was able to possibly go on all these cameras, and yet all these cameras, library, this, that, and the other, that would have shown a busted up taillight, right? It's not able to even show that. Like, look at it and spin it. Okay? That's how you'd want to look at it. And to me, that should tell you everything. Now, it is not a coincidence that none of the many cameras in the CPD Sally Port garage captured the condition of the right rear taillight upon its arrival at CPD, and before the first pieces of taillight lens material were recovered by law enforcement at 34 Fairview Road. The fact that the Commonwealth and its agent, the Canton Police Department, failed to preserve the footage in a forensically sound way and allowed critical evidence to be destroyed is not a coincidence, and goes to the heart of Miss Reed's defense and the credibility of some of the Commonwealth's most central witnesses. Even if ADA Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. I love it. Take that, you fuck. Woo! Go, Karen. Yeah, Karen, get them. I love that part. Anybody that, let's say that you weren't, well, then you suck, because anybody that's exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. See reporter's notes to master, blah, blah, blah. Closing her out. Evidence in possession of the police and Brady material, even if the prosecutor is unaware of it, so the prosecutor has a constitutional duty of inquiry. Following the February 2nd, 2022 preservation order, ADA Lally should have, and as a diligent prosecutor would have, promptly notified CPD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. The certificate of compliance ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but, and the Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal of the case. Those words are so profound. That last sentence right there. ADA Lally did anything but. What if anything? I love it. I love it. Do you understand? Like, people don't write this about other lawyers. Lawyers don't write this about other lawyers. It has to be this crazy. And that's why Alan Jackson keeps saying it. In all the years that I've been doing this and I was a prosecutor, I've never witnessed anything like this. Let's see. Number 5. The Commonwealth withheld exculpatory statements made by Jennifer McCabe. Flagrant violation of its obligation under Brady. Oh my God. In a flagrant. They use the word flagrant. You guys know that's like, The Commonwealth withheld the May 10th, 2024 exculpatory statement of Ms. McCabe, in which she denied traveling to the personal residence of first responding officer Sergeant Lank on January 30th, 2022, the day after O'Keefe's death, and then claimed she went there with Carrie Roberts to quote unquote pick up Roberts' daughter. Clearly, the Commonwealth was required, pursuant to their Rule 14 discovery obligations, to disclose the false statements made by Ms. McCabe to Lieutenant Tully regarding her visit to Sergeant Lank's house. Rule 14 requires automatic production of all statements of persons the Commonwealth intends to call as witnesses and quote unquote any facts of exculpatory nature. The Commonwealth's decision to preemptively reveal impeachment evidence uncovered by the defense to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a clear-cut violation of the Commonwealth's constitutional obligations under Brady. This is sick. The Commonwealth's egregious and repeated discovery and Brady violations require dismissal of this case with prejudice. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. See 14C1. For failure to comply with any discovery order issued or imposed pursuant to this rule, the court may make a further order for discovery, grant a continuance, or enter such other order as it deems just under the circumstances. Criminal Procedure Rule 14.2J, effective March 1st, 2025. Oh God, clarifying that permissible orders include dismissal of charges with or without prejudice. They just added this shit. Oh my God, I love it. Effective March 1st. This is why they waited. Oh my God, I love it. There it is. That's your bombshell. Look at this. Effective March 1st, 2025. When's that hearing, baby girl? And then this was the old one, 2016, that this is what you can do. Okay. Allegedly, LB dropping some bombs up on her. How special is that? Clarifying that permissible orders include dismissal of charges with or without prejudice, emphasis added. Such remedies can include the exclusion of evidence, Commonwealth v. Stanford, and even dismissal of the criminal charge. There is no question that on failure of the Commonwealth to comply with a lawful discovery order, a judge may impose appropriate sanctions, which may include dismissal of the criminal charges. Dismissal is appropriate. Remedial sanction as a way to cure any prejudice caused by the violation of discovery obligations and ensure a fair trial. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in there's no fixing this. Irremediable harm to a defendant that prevents the possibility of a fair trial. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the right of a defendant against the necessity for preserving society's interest in the admission of justice, right? And first, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should be allowed when the defendant can make a showing of a remedial harm to the defendant's opportunity to obtain a fair trial. In this situation, that's exactly what Karen Reed is facing. How can she get a fair trial? The Commonwealth hasn't even made a statement about that inverted video. Okay. Like Adam Lally should be outraged and acting like he had no idea about it. I am outraged and I'm demanding that these charges be dropped. You know what I mean? Like that's the type of stuff. First, where the prosecutor fails to, I just read that, sorry. Alternatively, prosecutorial misconduct. I love this word. Prosecutorial misconduct is this. That is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to a presumptive prejudice. In such circumstances, dismissal would be appropriate if needed, quote unquote, to create a climate adverse to a repetition of the misconduct that would not otherwise exist. This is where you teach these motherfuckers a lesson. Okay, is that right? Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with its discovery obligations. Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Ms. Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. A, the Commonwealth has failed to disclose evidence that it was obligated to disclose to Ms. Reed, which severely prejudiced her, such that a fair trial is not possible. Here, Ms. Reed has been irreparably prejudiced by the Commonwealth's discovery violations in this case. The first trial resulted in a hung jury precisely because this was a close case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Ms. Reed was constitutionally and statutorily entitled, the results of this trial may very well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witnesses in this case, including Sergeant Buchanan, McCabe, and Higgins. I would have added Carrie Roberts. but they're treating her like she's not important. So it's like a slap to the face, like, fuck you, Carrie, you're not even important. Moreover, the Commonwealth's continued piecemeal production of exculpatory video footage, which has, by definition, been in the Commonwealth's possession since January 29, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14 and Brady. It is well established that, quote-unquote, suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Brady versus Maryland. The Commonwealth may not withhold such evidence from the defense. To do so is not only a discovery violation under Rule 14, but also a constitutional violation. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage from the CPD and failing to properly preserve this exculpatory evidence has irreparably harmed Miss Reed. To this day, this is unbelievable. Unbelievable. Can't wait to see Colleen on the stand. Get your ass up here. To this day, the Commonwealth has not produced all of the video surveillance footage recorded at the CPD on January 29, 2022. Numerous camera angles and large swaths of time are missing. As a result of the Commonwealth's failure to appropriately image and preserve this evidence, video surveillance footage, which should have captured the condition of Miss Reed's right rear taillight at the time it was taken into police custody from multiple cameras at multiple angles, has now been destroyed forever. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29th, 2022, the defense would have conclusive evidence that Miss Reed's taillight was cracked, not shattered, when it arrived at the conflicted CPD, love it, on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day after the Commonwealth claimed Miss Reed had struck Mr. O'Keefe, that evidence would establish Miss Reed's innocence and be case ending for the Commonwealth. It should not be lost on this court that this video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. As a result, Miss Reed is left without the ability to forensically examine the CPD's DVR system to determine whether the many random clips produced by the Commonwealth in discovery have been altered, manipulated, or tampered with, and whether other clips have been destroyed. We'll go to that footer in a second. The Commonwealth's failure to preserve and produce this exculpatory evidence, which includes the destruction of all original and native video surveillance footage and the accompanying log files, has irreparably harmed Miss Reed. There is no lesser sanction that can cure the Commonwealth's failures to preserve this evidence. Exclusion of the video surveillance footage at trial would undermine Miss Reed's defense because the footage itself is exculpatory. Meaning, like, we can't just, like, we're not just going to throw it out. Like, we need that. Indeed, the very nature of the evidence is such that it is exclusion harms rather than helps Miss Reed. Just what I just said. The exculpatory evidence to which Miss Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by dismissal of the case. This was the footnote. Unsurprisingly, the Commonwealth is utterly unable to establish any chain of custody for the footage to this day, let alone explain how it had come to be inverted. Unlike the other video surveillance obtained by MSP in this case, the CPD video surveillance footage was never logged into evidence. There are no reports documenting the recovery of the evidence, and there is no documentation regarding its chain of custody. Even if this court disagrees that Ms. Reed has been irreparably harmed, the Commonwealth's misconduct gives rise to presumptive prejudice that warrants dismissal. This misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. These were not innocent mistakes. The repeated and flagrant discovery violations engaged in by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. Here at trial, God, that makes me want to cry to say those words like that, man. Like, this cannot happen in our country. Here at trial, ADA Lally, the Commonwealth and its agents intentionally withheld video surveillance footage from January 29, 2022. The Commonwealth sprung inverted surveillance footage on the defense in the middle of trial in violation of Rule 14, as well as its certificate of compliance. And then it compounded the violations by attempting to perpetuate a fraud on this court and the jury. By knowingly eliciting false testimony from Sergeant Buchanan on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. The inverted footage of Miss Reed's vehicle from its interior Sallyport camera was an unquestionably a false account of the true facts, and the Commonwealth passed it off as an accurate depiction of the SUV when it arrived at the CPD on January 29, 2022. And that, in quotes, as seen in the video. No law enforcement officer approached the rear right taillight. The Commonwealth's deliberate attempt to use discovery violations to its advantage in an effort to perpetuate a fraud on the jury is the precise type of conduct that requires dismissal. Moreover, both ADA Lally and ADA McLaughlin were caught. They were caught withholding exculpatory information from the defense at the first trial. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to Ms. McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligations under Brady and its progeny. What am I doing? Even after trial, I need to eat. Even after trial, ADA Brennan located exculpatory video surveillance footage, which was withheld from the defense. This is so crazy. I love it. Get him, Karen. From the defense at the first trial, and established that Higgins made a phone call at 1:34 a.m. outside of the CPD. This exculpatory impeachment material was never turned over to the defense. The Commonwealth's repeated violation of its constitutional and statutory discovery obligations were calculated and intentional and were done in an effort to secure a conviction at all costs rather than pursue the truth. Indeed, as discussed above, the Commonwealth's misconduct has resulted in a violation of Ms. Reed's constitutional rights, so as to give rise to presumptive prejudice. The discovery violations in this case constitute a Brady violation and thus violate Ms. Reed's due process rights. To establish a violation of the rule of Brady v. Maryland as incorporated into Rule 14, the defendant must demonstrate upon review that evidence actually existed, that evidence would have tended to exculpate him or her, and that the Commonwealth failed to disclose it upon proper request. All which is right there. Given that these facts give rise to presumptive prejudice, and considering the need to, quote unquote, to create a climate adverse to repetition of that misconduct, this case should be dismissed. To allow this case to proceed to trial would create a climate in which these types of flagrant constitutional and statutory violations are regarded as permissible. Such an outcome cannot be tolerated by this court. This is why I think it's going to get thrown out. This is the reason. You might as well just like take Massachusetts and let everybody just do whatever they want. Okay. The Commonwealth's clear, repeated, and intentional failure to comply with discovery orders requires an appropriate remedy in this case because the discovery violates concern of failure to produce and preserve exculpatory evidence, and because exclusion cannot remedy the violation, the only appropriate remedy is dismissal of the case. Because of the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, the withholding of material and exculpatory evidence, and failure to comply with the court orders regarding discovery, Ms. Reed's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. The defendant therefore respectfully requests this honorable court to order that the case be dismissed with prejudice. Now, all this redaction that's about to come up, this is so that Jennifer McCabe can't see it. That's who they're protecting this from, in my opinion. Dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to a fair trial by an impartial jury. Oh, wait, no, we're at the jury part? Okay, no, this is something else. Additionally, this was another bombshell that we didn't know about. We got this new blurry video last month, and now here. Additionally, dismissal of this case is also required to remedy the violation of Ms. Reed's Sixth Amendment right to an impartial jury. All of this is redacted, okay? But we get to an important part that's not, and because of it, we were able to look up a couple cases, okay? So notably, a juror may never be dismissed because of their views on the case or for reasons having to do with their relationship with other jurors. Instead, jurors may only be dismissed for reasons, in quotes, reasons personal to the juror that have nothing to do with those views on the case or relationships with other jurors. And so when you look up these cases, and then my Bella and I were talking about it, dismissing a juror like there was a dismissal. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to an impartial jury. And then when you, like I said, read these cases, it goes here, here, and we get to here. And we hear about jury tampering. You guys, this is going to blow your minds. Jury tampering, such as this, is presumptively prejudicial. See, and you need to look up this case and see what this case is about. We'll talk about it later. This case is about somebody getting paid off to bring in a result, okay? And then finding out about it after the fact. Okay, so go check out this case. So this case. And triggers a burden on the government to prove that the tampering was harmless to the defendant. So it would be like a juror coming forward and saying that they knew of something. Okay. The Commonwealth cannot do so here. This is crazy. As per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be, quote unquote, in the best interest of justice. Judges can do this at any time during the trial process, although the procedural burden and standard vary at various stages. Post-impanelment and pre-deliberation. If a judge is alerted to a potential misconduct of or affecting jurors, the judge first, quote unquote, determines whether the material raises a serious question of possible prejudice. If so, or if she so determines, she must then hold a hearing to inquire further into the alleged misconduct. None of that shit happened. Okay. Then we got this, redacted. Here we go. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to dismissal of jurors. Those procedural protections were not provided here. These constitutional violations, along with, so boom, what Bev's conduct, everybody's conduct, the egregious discovery violations discussed above demonstrate the inherent unfairness of the proceeding against Ms. Reed and warrant dismissal of the case against her. And then this is where the bomb gets dropped. Okay, we've all been waiting for it. Okay. Karen Reed is entitled to an evidentiary hearing where there will be witnesses and evidence presented to see if and in fact this case should be dismissed. But what people aren't expecting is right here, for the above reasons, Ms. Reed respectfully requests that this honorable court grant the defendant's motion to dismiss. But should you not, even though it's warranted, although dismissal is required and appropriate under the circumstances, but in the alternative, guys, the defense is seeking and is motherfucking entitled to an evidentiary hearing on these issues attended to the Brady violations and juror interference. They're calling it juror interference. I want to make sure that that was underlined as well. Juror interference. Like, oh my God. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant Buchanan, Colleen with an 1L Crawford, other members of the CPD, and Lieutenant John Fanning. Come on down, you son of a bitch. I'll see you guys on the flip side. Bada bing, bada boom. I just want to say thank you to all the mods. Thank you to everybody that was in chat. Patricia, thank you so much. You sound so excited about this, Lana. I'm stoked about it. Karen Reed's innocent. Go Karen Reed. They're liars. The data proves a bunch of things. They try to destroy her character, her reputation. They've come for her. And I just love to see that everybody's rallying for Karen Reed. So thank you so much for all the super stickers, super chats, and then the Cash Apps. And I really appreciate it. So keep showing up for Karen Reed. Keep showing up for the truth. But regardless of what side you are on, if you think guilty or innocent, nobody should ever have a trial or go to trial or be prosecuted like this. And this happens all the time to the minorities in this country. So thank you. Go get them, Karen. Truly great. Thank you for the breakdowns. Thank you. Appreciate it. Now I'm going to go work this voice out. Peace out, guys. Irish guy. Irish goodbye. At least I'm getting a little bit more. But next week's going to be awesome.